All right, there we go. Hello, everyone. This is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup. We're doing it Sunday, August 4th for Monday, August 5th.
Because I'm
But
in a hurricane.
yeah, and Brad is in Florida in a hurricane, so we'll see if you drop off, we'll understand why.
I'll be
So,
good.
but
If I or blow away, you never know what happens.
there you go. Well, we got a pretty interesting week here, so why don't you kick us
Great
off
week.
here?
Yeah, I love this. Let's start. And I hope you and I disagree on this because I
Good.
think it'll be a great conversation, but we'll see where you go. And so people know, the viewers, we don't talk about this stuff and get our opinions synced up. It just is as it is. But we're going to start in Odessa, Texas. And we've got a fire captain who's demoted to lieutenant because he allowed a photographer to take and shoot photos while nude on a Ector
Not the
County Sheriff's.
photographer. Not the
What's that?
photographer. The photographer
Yeah.
was not nude.
Well, no, photographer is not nude, but he allowed the photographer to take nude photos. And I guess the photos were taken of a Ector County Sheriff's Office corrections officer. But it was all voluntary. In any event, I think the captain tried to do the right thing, at least insofar as saying you've got to take everything off of all the names off of the trucks and the turnout gear, and they can't show. I think he was trying to keep things anonymous. It obviously didn't happen. So in the picture, the woman's topless, is wearing firefighter turnout pants and standing in front of the fire engine. Yeah, in one of the photos, you could see it says, the number 2 on it and there's a Texas license plate, but you can't really tell whose it is. And I'll share in a moment, I have mixed opinions, but in any event, there is a policy, rightly so, that says members are not authorized to use city's equipment like this, right, for anything other than official business. So look, he probably should have gotten permission going up. Wouldn't think a captain should be, authorizing use of, municipal equipment. Probably should have gone all the way to the top, where I presume they would have said no. So I get that. I don't think there's any legal issues at stake. He violated a policy and that was it, right?
Yeah, well,
But
I think one of the issues I take away from it is the importance of having a policy that anticipates this. There was some firefighters one firefighter in particular, it's a friend of mine, but he was disciplined in Los Angeles, and he later became the fire chief, but the pictures of him surfaced about 20 years later. But the question became, and that actually surfaced after he was disciplining, as the fire chief, he was disciplining some other firefighters for posing. And there's a lot of questions here, particularly where you authorize people to come into the station and take pictures, which happens, by the way, every day.
of course,
There could be fire buffs from out of town, or other people come in, or public has a right to film and all that. But sometimes you know ahead of time what exactly they're going to be doing. But very often they say, "Hey, can we take some pictures?" And so what we want to have are some limits in the policy that address just what you can and what you can't authorize people to take pictures of, and also the posing of apparatus, posing of equipment, the use of turnout gear for posing. And if you don't, here's the thing, if you don't have a good policy, then you have this mess happen, and you're trying to charge somebody with conduct unbecoming, which is, I think it fits here. I'm not saying you can't make the case, but I don't know, anytime I have to discipline someone based on conduct unbecoming, or one of my clients does, the hair on the back of my neck stands up a little bit, because it's vague. And certainly if somebody does something really over the top, no problem. But when things are, on the borderline, this is not on the borderline, I'm not suggesting it is, but you want to have a policy that clearly covers this type of activity.
the problem with this is the policy isn't written in a way that addresses constitutionality. And I'll say it this way.
Mhm.
You can bet if a little league team showed up
Yep.
and wanted to take pictures in the
Yep.
same turnout gear in front of the
Yep.
truck,
Yep.
would have been no issue whatsoever.
Yep.
The constitutional issue here is that the city finds the nude photographs objectionable, right? And so we have a policy that's meant to say, look, don't use the equipment for whatever. And it's not personal gain here. He didn't get paid, I don't think, although there was some thought that maybe he was trying to hit on the subject of the photo. But again, when you have this neutrally, this facially neutral policy, but you're going to apply it differently, does the policy become unconstitutional because you're prohibiting what you view as distasteful? Yet again, Little League, this never would have been an issue.
Yeah.
Nude person, it's an issue.
And
right,
I've
and he's
spent
going
the
to say you're
flower of
treating
my
me different.
youth, spent the flower of my youth perfecting the right language for a policy to address exactly that. Okay, and it's really critical that we respect whether it's the Little League, whether it's the Cub Scouts, whether it's the Girl Scouts, whoever it may be, they're going to come in and take pictures. They have a First Amendment right to take pictures. Now, we don't have an obligation to pose. We don't have an obligation to allow our, other than the apparatus, but we can't. They have no First Amendment right to put on our turnout gear and that type of thing. So we want to have a policy that regulates posing and that type of thing. In the policy language, we want to have that. But again, we're walking a balance between allowing, exactly as you said, the Little League pictures, but drawing a line when it comes to obscene, nudity, or those types of offensive types of pictures. So
and that word offensive or objectionable, whatever. So this is why, again, if you subscribe to the Curt and my must-have policy service, this is one of those policies that would be coming out that would address this. But this happens all the time. We've seen this a couple years ago with the Hooters girls. Came down and they weren't nude. Right, they're just in their normal restaurant uniform.
They have cost a number of firefighters their careers.
Oh yeah.
And I've had to actually investigate some of them. I've been involved in advising people who are involved in some of these investigations, but Hooters girls, because it is on the line there, it's not a good situation. We need a clear policy up front to address those types of things.
Right, and you can't, as a layperson, I challenge you quickly to write a good policy on this.
No, you can't. No, you can't.
Right. There's no way. It's too complicated. There's so many constitutional issues, right? Just treating somebody differently and the words you use, objectionable or, offensive or.
My first few drafts years ago, 15 years ago, when I first started working on this particular one, because this really wasn't an issue. Before social media, it wasn't all that big an issue.
Right. Calendars maybe. Right?
Really where it exploded was Facebook and now it's even worse with some of the other social media platforms. But my first couple of go rounds, it was pointed out to me that some of the language was ambiguous, and so what I do, and I'm sure you do, is we read the Supreme Court cases.
Yep.
And we use the exact same language that the Supreme Court uses. Now, if you want to object to our policy language, you've got to object to what the Supreme Court said, because we're using the same language. And they've got to say, oh, we were ambiguous when we were unconstitutionally ambiguous when we said that. They're not going to say that.
Right.
And neither is a lower court. They're going to say, okay, yeah, that's the language the Supreme Court used. It's okay for us.
And I got to tell you, all the time I have clients sending me policies, say, can you read this and review this? And I send back, I said, here's a completely new revision. They're like, well, why don't you just edit ours? I'm like, because you don't understand what goes into drafting policies. There are cases, there's statutes, there's language, there's constitutional rights. You can't just put words on paper. You're starting from the beginning.
I love editors. And you and I don't have editors. We are our own editors, but I love editors because they just kind of move words around and they have no conception about why an attorney would phrase a certain provision the way we phrase it.
Right.
So very, very important. Yeah.
But great case and a great lesson. People just don't put words on paper and think it's acceptable because you're going to create this type of ambiguity. Why is it okay for the Little League, but not okay for somebody taking nude photos? Yeah. Okay. Now, this is a great example of just a question of fact. Same meeting, same issue. It's going to be, this all centers around basically one meeting and what happened at that meeting. So as we tell you about this, as the viewers, think about how could you, who are going to be in a ton of these meetings that are going to challenge about what happened at that meeting, how could you prevent this situation, right? And there are definitely ways which we should talk about. So here's what we have. Not complicated facts. We have an assistant chief. He retired, and the question is going to be voluntarily or not voluntarily. All right. He retired shortly after he made a complaint about ethical violations and improprieties. I should back up. We're in South Carolina, and he sends complaints way up the chain to the South Carolina Ethics Commission, and I would suggest he skipped probably chain of command by making internal reports. At least I can't tell from what I see that he did that. In any event, he makes these complaints. He's brought in for an interview. And from there, it's a question of what happened. He claims he was forced out. He was told, you need to go. The other side is, no, we just gave him some options, right? We told him he could, there's a lot of things he could do. One of them's resigning, but there are other options as well, right? So the whole question here, because this is just a suit, is, was he forced out for making complaints, being a whistleblower? Was he not forced out? And so I question, Curt, what could they have done as the entity that met with them? And I'll throw out one suggestion to start, but what could they have done knowing that, look, the guy just made complaints and now you're going to have a meeting with him. Or you should know, this is going to go badly if it doesn't go his way because he just made complaints. And what happened? So my suggestion here at a minimum is record, with everyone's permission, record the meeting so there's no question what you said. Did you force them out? Did you not? But it's a great classic case of, what really happened. And a jury's going to have to figure it out. And the reason I think a jury is going to look negatively on this is because as I look at it, one of the options they offered was resigning. So I think a jury's going to hear that and be like, well, they did kind of push him out the door by why would you tell someone they could resign? Why would you say that to somebody? And that will be their argument. Yeah. Anyway, your thoughts.
Well, I think the recording is the best way. Okay. But sometimes it gets past you and you say, damn, I should have recorded that meeting. Sometimes it's as soon as the door closes and the person leaves. But I think the next best option is some sort of a post-meeting contemporaneous documentation of what was said. And we're not talking about something that you're going to write weeks and months afterwards. We're talking about something as soon as the meeting closes, you keep notes. I know many chiefs, this is kind of an old school practice, but they keep a notebook of every meeting that they've had. And then after the meeting ends, they'll keep it in like a journal. And often these are bound with numbered pages so that it's not a question that you stuck a page in a 3-ring binder, that it's actually, now in the digital age, I don't know what the equivalent of that is. I don't know how you actually document that. You send yourself an email, some people will say, but again, I think some sort of contemporaneous or post-meeting contemporaneous documentation of what was said. It's not going to be as good as the recording, but I think it's sort of the next best thing. Another option is if going in that this is going to be a contentious meeting, having a witness that's there that's going to be able to support your version of what happened.
Yeah, I like the memo at the end. If you didn't record it, I like the memo at the end, which says, just to recite, here's what we said in case there's any confusion. Here's what we meant, right? And you put it together. You don't have to resign. We're not asking you to. We're not suggesting you do. You could stay, right?
That's actually a little different than what I said, but you're absolutely right. Now you got me thinking about it because you kind of, you start thinking about this stuff and you think of other ways to do it. But even a post-meeting email, hi, this is Chief Verone. I just want to confirm our meeting today and just kind of go over the various points, put it right down. Then if the person's got an objection to it, then you reply back and say, no, that's not what happened. Right. But, then it's documented.
And look, and the response to that of, oh, well, if you think that's not what happened, here's what we meant, so let us be clear, right? Look, and one other thing, if you're going to make a quote-unquote offer, right? You can do A, B, C, or D. Why not bring that in front of you, right? Here's our letter to you. This is what we want to talk about. Here's our offer to you. Here's our options. But I got to tell you, in my view, if any one of these options is you can retire, why are you saying that?
You know,
Why are you,
I
right?
say that in my class all the time that, when someone, particularly I'm talking about my discipline class here, and the fact that you really don't want to be the one to bring up retiring.
There we go.
And people say, well, we do it all the time. And, you just don't want to be that person for this very reason, that you're going to be in a constructive discharge or constructive termination type of scenario where you don't want to be the one that brings it up. They bring it up. Okay. There's not much you can do other than my bias is to encourage them not to. Why don't you think about it? Go home and talk to your spouse, talk to the union rep, talk to your friends. Don't rush into this.
Right.
But
And look, one other thing is when somebody brings you a complaint,
Mhm.
right? I have seen cases, certainly you have too, where the charge against them is you went around the chain of command. We gave you a way to give us the ability to rectify it, to tell us about it. You didn't tell us about it. Maybe he did, I don't know, right? But then he goes all the way around the chain of command, all the way up to, state ethics committee. But it seems to me, I don't know that I would be meeting with him at all. If this was reported to an agency,
Mhm.
why are you meeting with somebody who just filed a grievance or made a complaint?
Yeah.
I think the meeting in itself is improper because what's the point of it,
Well,
right?
couple of things happen here because he reported it to the South Carolina Ethics Commission, and they said it's not going anywhere. They said this is not something that we consider a violation. Then
Oh, okay.
he went to the South Carolina, the Law Enforcement Division, which is their state police. It's the South Carolina State Police, who in turn said we're not going to go anywhere. This is not going anywhere. And then they apparently got back to the city
Okay.
and said, we received this complaint. We don't see any criminal violations, so it's not going anywhere. And that's what prompted the meeting. But he still, based on that fact pattern, he still could qualify as a
Oh,
whistleblower.
yeah. Yeah.
It's gonna come down to whether or not there was some retaliation. Now, the defense is that according to the answer, which we don't usually get the answer before we do the post. So this is kind of
Right.
interesting.
Usually you're quick, faster than
Yeah.
that.
Yeah, and I'm glad we were able to get the answer, but the answer suggests that he actually wanted to become the fire chief, that he was a little put out because the current chief hadn't retired. And so now we start to see some that would be the defense. And the defense is going to focus on, he had a motive to either say it happened this way or perhaps perceive that it happened this way. In either event, this is how he saw it happen, and this is why, and that's going to be their defense.
Right. So you really got to be very careful when you put yourself in these scenarios. And look, maybe the employee was setting them up. Maybe the employee was being set up. I don't know, but I'm not sure this meeting is how I would have suggested, right? Because what's the point? If you've got a complaint, let us know what the complaint is, investigate the complaint. Why are we talking about his future at all, as far as I'm concerned? That just has bad connotations. So. Okay, well, some good news out of a horrific incident. We have 3 persons who have been charged with starting a fire that claimed the life of a Chicago firefighter in 2023. Firefighter Pelt was killed in April of 23 fighting a fire in Chicago. OFI there then fines and is charged 3 individuals with arson and homicide charges for setting the fire. There's also insurance fraud and fraud, forgery. One of them owned the home that was burned down. So anytime we can bring criminals, and I'll say it, murderers or alleged murderers to justice, I think we should. They're presumed innocent until a jury finds them guilty. The hard part, anyone who's been an arson investigator, I have not been, but we all know how hard it is to prove arson. It's so tough, but there hopefully will be some justice for the family.
It's
And
a lot easier if one of the defendants will roll over on the others.
And you got to imagine, you've got to imagine that's what, at least on TV, that's how it happened. But
Well,
that's
in real life, it happens too. And sometimes it doesn't necessarily happen with the arson, but one of the arsonists or one of the people involved gets arrested for something else that might be more serious and says, hey, if you go easy on me on this one, I'm going to roll over and tell you about this other one. And when I did some work with the attorney, I was an intern at the Attorney General's office while in law school, and we had a couple of cases exactly like that. So.
all right. Why don't you do this one? This is interesting. We've got the IAFF here. Do you want to tackle this?
I will. Full disclosure, Frank is a friend of mine. We are on the NFPA 1710 committee, and I have the utmost respect for him. And like Frank Ritchie, he takes no baloney from anybody. You know, that's just the way he rolls. And it's not his first lawsuit. It's not his first rodeo. And again, you're not going to slip something past Frank Ritchie without a fight. And Frank Lima, who is now a captain in the LAFD, has filed a federal court lawsuit. And what he's alleging is he attended, and now Frank has got a couple of different things. He was the union president, I believe, of Los Angeles firefighters, IAFF Local 112. Now, I believe he's left that position, but he is on a national level. He is IAFF General Secretary Treasurer. And whether in his role as a representative for IAFF Local 112 or as an IAFF representative on a national level, he participated in a job action. I believe it was outside a hotel, if I'm not mistaken. Yeah, hotel workers. And apparently, I'm not sure how it works. I don't think it's a normal practice of law enforcement, but they apparently arrested people and then they let them go within 10 minutes, which I don't fully understand how that. I question whether or not it really even is an arrest, but I think out of an abundance of caution, because of his position, he disclosed it to the city. He immediately said, I was arrested, even though I was released 10 minutes later, I was arrested. Our rules require me to report that. And the city apparently didn't do much for almost a year. Now, in California, once a fire department is aware of a disciplinary infraction or possible disciplinary infraction, they have a year to complete the investigation. And so just about a year from the date that he reported it or it occurred, he was disciplined. And the discipline was a written reprimand, but he's concerned on a couple of counts, which I think are legit. Number one, it could affect his future promotion, and I'm not sure how their promotions go. I know one of the nice things in Providence was it was pretty much rank ordered. If you come out number 2 on the list, then the first guy is going to get promoted, and then you're going to get promoted next. There's no way to bypass anybody. Many departments have systems where the next person up, the chief has the ability to pick from the top 3. There's other ways that you can be bypassed, and maybe even in promotional scoring or promotional points, something like a reprimand can count against you. So bottom line is, he felt like it could harm his ability to move forward in the organization. But I think the even bigger issue is this could have a chilling effect on other union members participating off duty in these types of activities.
I think that's the big issue. To me, that's the big issue right there.
Right. And he's alleging, so there's certainly a First Amendment right there. This, free speech, but there's freedom of association. There's also state constitutional protections. There's some statutory protections that allow political activity. And arguably, this is political. I mean, on one hand, it's sort of economic, but on the other hand, it is political. And then there is some protection in the Firefighter Bill of Rights. So going after all of those issues, it'll be interesting. I don't see what the city gains from trying to fight this.
No, I agree.
I just don't see fighting this out in federal court is going to really do much. But we'll see what happens.
All right, so our last one is going to be New Jersey. There's a couple of facets to this, and I really find it interesting. I wanted to end with it because, well, the part I get out of this, and we'll talk about it, is progressive discipline. But here's what we get. We get a court decision, and we have a firefighter who is full-time firefighter, but also full-time military, and never disclosed to either, I guess, but certainly not to the fire department, that he had another full-time job. Now, which is a little strange because you would think pensions might come into play or
Well,
something.
and I think what's really important is both of them prohibited that. You needed to get permission. And the
Right.
military in particular, you could only have a part-time job and it cannot interfere with your military work. And I think it was limited to whatever part-time employment.
Yeah,
The
and
fire department was a little different.
right, the firefighter tried to kind of play, I guess, ignorance, right? He said that he didn't really think it was necessary to inform the fire department of active duty status, right? So he, didn't. It goes before an administrative law judge. The administrative law judge didn't find him credible, found that it was, a very severe penalty. And this is the part of the decision. We all take something away from decisions as your lawyers, that you find interesting. But for our purpose, there was a progressive discipline policy here, and they skip right to termination. And the court recognizes, because I think you take a different view. I can't wait to hear. I hate progressive discipline. And I always say, like, okay, so and I have two reasons why I hate it, two roles why I hate it. One, I'm like, okay, well, I was late by an hour. Okay, well, that's a verbal. Okay, but next time I failed to submit my reports on time. Okay, well, that's, I guess, the first offense. That's a verbal. Well, the next time I murdered one of my coworkers. Well, I guess it's the first offense. That's verbal, right? So one reason I hate progressive is because I feel like it treats every offense differently. Another, a second of maybe 3, 4, whatever reasons I hate it, is because you're forced to treat people equally. And I don't believe in that. I don't believe that a 30-year veteran who's never been late and is now late for the first time after 30 years should be treated like your first year member who's late or whatever, right? And he's done the exact same thing, but they're not the same people. 30-year veteran, clean history, not. And then we've got this. The third reason I don't like progressive, but the court really hits this. I don't like progressive because, as I said, well, it's only the first time I've murdered my coworker. Yeah, but it was so bad, right? You can skip all the progressive. And the court recognizes that in some instances, that progressive discipline can be bypassed when the employee engages in severe misconduct, right? And especially when the employee's position involves public safety and the misconduct causes risk of harm to persons or property. So the court's like, here you can jump it. I don't like progressive, and now I want to hear what you think, Curt, because I simply don't believe that everybody should be treated equally. I believe certain penalties, each policy, the violation, I believe, of each policy should carry with it a separate penalty. For example, sexual harassment might be different than being late to work. I think everything should have its own separate severity, and progressive discipline, to me, doesn't take into account the policy you violated and the severity of that violation.
Okay. I mean, I guess I disagree, but I think at the end of the day, we're saying the same thing. But I think, there's enough room there. There's enough space where we can disagree on this. And I think people should be treated equally. In fact, it's not just me. The Constitution says they have to be treated equally. So,
Yeah.
but who cares? But at any rate, but I think it depends on what you define as equal. Okay. A 20-year veteran with a clean record should not be compared to a brand new person with 18 or a relatively new person with 18 months and 10 disciplinary infractions already.
Right.
A 20-year veteran with a clean record should be compared to a 20-year veteran with a clean record. So we should be evaluating apples to apples.
Yeah.
Okay. So I think that's number one. Number two, some of what you said kind of sounds a little bit like a thing called the disciplinary matrix, where if you do something first offense, this is what you get. But then you do something else first offense, this is what you get. And your hands are tied. And progressive discipline to me means that if you come in late, and then the next thing you do is you come in AWOL, you don't even show up for a shift. That there's a progression there, and that you've now had two different disciplinary infractions, one a little bit more serious than the other, and that we're entitled to take that into account. So, but I understand what you're saying, and one of the reasons why I included so much of the case in this is I wanted folks to read the language on progressive discipline and see what the court was looking at, what it found to be relevant, and how it approached that difficult issue of it is possible for you to do something that is so significant, even though you've had no discipline problems in the past, that this is a terminable offense.
Yeah.
And the court and the administrative law judge, and then followed by the Civil Service Commission, followed by the court, all felt that that was appropriate.
And look, we all know that discipline is, if you're in a union, mandatory subject of bargaining, right? So most unions, if not all, I don't want to speak for everybody, but seem to like progressive discipline because it gives you more of a shot at the apple. On the other hand, I've, working with and against unions and as a fire chief and on the opposite side, I've had employees even saying, why are you treating me the same way as you treated someone else? I've been here 20 years and I'm, have a great record. And I'm like, well, hands are tied. You wanted this type of discipline. I agree with you. I like treating the 20-year like the 20-year. I don't see it working that way in practice, unfortunately, but I think that's great.
Yeah, people will argue. I mean, if I'm representing the 18-month firefighter who's got a bunch of disciplinary infractions, I am certainly going to point to that 20-year veteran who didn't get terminated and say it's unfair, you're not, but at the end of the day, it's going to be up to some sort of an adjudicative officer, whether it's the fire chief, whether it's the Civil Service Commission, whether it's a AAA arbitrator. They're going to actually have to say, no, no, equal for a 20-year veteran with a clean record is a 20-year veteran with a clean record, not an 18-month problem child with 10 disciplinary infractions.
Right. And so usually,
it's up to the adjudicator, not the advocates are going to advocate, just like you and I, we're going to advocate for, you shoot from where you sit. I had my first captain, Albert Cini. It was one of his favorite sayings, but you shoot from where you sit.
Yeah.
And
that's true. And look, any lawyer will defend the first client that walks into his office, right? If you're the accused and you walk in first before the accuser, I guess we're representing the accused, right? We'll take your side. But normally, like what you just said about, oh, he's treating the 20-year veteran differently than me. But that's not how it gets phrased. What it gets phrased is, you guys have been friends for so long, you're treating your friend better than you're treating me. Well, yeah, we've been here 20 years. We're friendly. He hasn't given me problems like you have in 18 months, right? And
throw in a protected class and there you go.
Even worse, more challenge. So anyway, so I will say that I think I'm the minority. I think I'm right, but I think most lawyers and certainly most unions want progressive, or I call it step discipline. They want that. I would prefer, and look, I'm okay with if you really want to take effort in each policy, you put the violation of this. We always have the standard language can result in termination, right? Yeah. But if you want to be really good and spend a lot of time, you could put progressive discipline within each policy. But some policies are, you violate this, you're done. There is no progressive. And if that's the case, your policy needs to say that, right? If your policy is going to be deemed, the violation of this policy is so severe that we're going to skip progressive discipline, say it in the policy. Now, the problem with that is your policy, which is not approved by the unions, going to, contradict the CBA, which gives progressive discipline. And that I was surprised. I didn't see it get raised here where the union would be able to say, wait a minute, I'm entitled to progressive discipline. It doesn't matter how severe it is, but I haven't seen how the CBA was written in that case either and how the policy was written. But I would be okay with progressive if the policies can say, no, first offense of this gives you a week at home, right? And that type of thing. You touch somebody inappropriately, you make a racial joke, you make a sex joke. We're not giving you a verbal warning on the first time.
Yeah,
right?
one of the challenges, one of the challenges you face is that somebody may have done 10 things, and now the 11th thing is relatively minor, but that's enough to kind of tip the scales. That look, we've told you, and you just keep ignoring the rules, or you just keep being insubordinate, or whatever it is. That one insubordinate may not be the type of thing to normally get someone terminated, but because of your disciplinary history, it's obvious you're not getting the message.
Right.
You
Right.
know, so
And you know, it's interesting you say that. I'm sure I haven't attended, but I always point people you should attend Curt's disciplinary class. But you know, when somebody accepts, because I've had this many times, they accept the punishment, but say, I do it under protest. I accept it under protest. My answer is, minute. So you don't understand what you did wrong.
we have
So
an Alfred plea.
right, right. But that's what it is. It's you can punish me. I'll take it, chief. That's fine, but I don't agree with you. And so the purpose, go back to Fire Officer 1, right? We all know the purpose of what? Discipline is to correct the action, not to make you sorry, and so it doesn't happen again. So if they don't accept the punishment, then what are we doing, right? Okay, well, you don't accept a week, I'll give you 2 weeks. It doesn't make them accept it or understand it anymore. So I kind of find their attitude after is, how do you correct that? What does it take to convince you that what you did was objectionable or wrong or a violation of the policy?
Yeah. And if we want to get into my toxic employee class,
Right.
there is no amount of talking to these folks, that someone who fits into that category. There's no amount of talking that's going to convince them that they were wrong. It's always somebody else's fault. It's the union, it's my officer, it's the guys on the other shift, it's the training division, it's HR, it's not me.
Right, because you're not programmed. You said it before. I think you've learned in some of your forensic psychology that it's the mentality of the person. They can't do any wrong. It's never their fault. It's always somebody else. I'm always right.
Yeah, absolutely.
And I don't think you're going to correct that no matter what you do. But that's the
You're
problem.
not.
Where I
You're
was
not. And
going,
all we can do at that point is just, document, because at some point there's going to be an exit ramp that's coming up. So,
right. And that was kind of what triggered that is when we're saying, okay, you give someone a week, they protest, or you give them a day, they protest, whatever. Their reaction to the discipline matters too, right? Somebody who comes to you and says, Chief, I screwed up. Let's take it. I'm sorry I was late. It was like my third time. I'll accept whatever you want to do to me. I was wrong. Well, wait a minute. Then the question is, okay, we're going to give you the discipline because we have to, right? That's our policy. We need to hear
and
the
we need to be
policy.
consistent. Right.
But shouldn't we document, I was sorry, I accepted it. How I reacted to the discipline matters as much as I say I wasn't wrong.
I got to get you into the class because we talk about that very issue, because with a disciplinary matrix, many departments have a disciplinary matrix. So you do this first offense, you get this. You do it second offense, you get this. Okay. Which, for reasons of race discrimination, gender discrimination, favoritism, nepotism, all that, fire departments have had to go to that. The alternative to that disciplinary matrix is a thing called an administrative insight. Administrative insight is a narrative that we write about why we're giving this particular employee this particular penalty. The disciplinary matrix ties the chief's hands.
Oh, yeah.
Okay. Whereas the administrative insight, you can take things like that into account, that the person did acknowledge responsibility, that they agreed, they owned it. They weren't trying to shift the blame someplace else. Therefore, again, we might go a little easier on them. On the other hand, somebody who is blaming other people, refuses to acknowledge what they did, refuses to accept responsibility, is pointing the finger in all these other directions, that might be a reason why we go a little bit steeper on the penalty.
Agreed. And discipline is so difficult. I have a case now we'll talk offline about, but these things you discipline somebody for something they legitimately did wrong. Sometimes they feel like they're setting you up. They claim an EOC violation or a collective bargaining negotiation or an NLRA violation, concerted activity, whatever. I mean, they almost set you up with what they did, and they're teeing you up to discipline them. And I really feel like they are. I feel like some employees tee you up. They said, like, okay, take a swing at me. I'm going to do something wrong to provoke you. You react exactly as they set you up, right? Then you do it, and they're like, now I'm going to sue you. That type of mentality kills me. Discipline is so tough. That's so tough, especially in a paramilitaristic organization.
And we hate it. That we hate it. I hate it. I hate having to discipline people. It goes against our culture. But on the other hand, if we don't, then we end up with these major scandals that we're like, how did this happen?
But what I like about this decision, tying it back to the New Jersey decision, and I think everybody should remember this line in this decision, when public safety and public lives and property are at stake, this is justified. And I think that was one of the first times, not the only time. I've certainly seen language where courts recognize the paramilitaristic, structure to organizations and realize that chain of command is a life or death issue. And when you start violating chain of command, or you start violating rules, I didn't think this was a perfect example of something that threatens life and safety, but there are certainly better examples, I think. But that's at least a court's recognition that this is not like your normal job that, where you treat people differently because, I don't know, morale or something, right? This is a life and safety issue in the fire and EMS service. And good for the court at recognizing that, right? This is not a normal run-of-the-mill employer-employee relationship. So that's it for the week.
All right, that's it. Now, how long you down in Florida?
I'm down for a week. I've only got another day and a half of this hurricane left. I'm lecturing in Key West and, or not Key West, I'm sorry. I'm lecturing down in Fort Myers, just above Key West, lecturing down in Fort Myers on must-have policies to about 17 departments, I think. So I'm excited. So I'm down here meeting them, and hopefully they will sign up for our must-have policy service. But we're going to do a pretty fun lecture. And, I got to tell you, almost if you're watching this, almost every session we're talking about policies you should have. If we haven't unintentionally beaten it into your head,
we don't need to advertise it anymore. But the point being is the policies are just so critical.
Oh.
They're critical.
We live or die in our policies.
Yeah.
You want to lose in court, don't have policies.
Yeah.
Very simple. Or have poorly written ones.
All right. So that'll do it for this week. Brad, we'll see you again next week. Safe travels. All right.
Absolutely.
And that'll do it.